Welcome to the Middle East Institute. Our lecturer today is Ben Saul, who's a Challis Chair of International Law at the University of Sydney, and I think possibly the leading scholar on the definition of terrorism in international law. And Ben is also a practitioner and has spent much of his time traveling to unusual parts of the world to meet violent non-state actors from Asia to Latin America to the Middle East. So without much further ado, Ben, the floor is yours.
Good afternoon, everyone. I'd like to thank the Middle East Institute for inviting me here today, and I'm looking forward to talking with you this afternoon. I want to talk to you today about a book I'm writing based on interviews with members of armed groups in about 12 countries, from Polisario in Western Sahara and Algeria through to FARC in Colombia and a whole bunch of groups in between: communists, national liberation movements, nationalists, rebels, and religiously inspired groups as well. And the book really started with an intuition. We spend so much time talking about terrorists as outlaws and trying to kill them or lock them up in jail. And it occurred to me that, of course, even in war, in places where terrorists are active, everyday life goes on. People are born and die, they get married and divorced, they buy and sell or inherit property, they steal chickens, beat each other up, they earn income and pay tax, they get into disputes with their neighbours or with public authorities. And yet, at the same time, in many of these areas, state law and legal authority disintegrates in the face of insurgent violence. Globally, millions of people live in areas controlled by non-state armed groups, whether you call them terrorist or classify them as terrorist or otherwise. And so my intuition was, well, what do terrorists themselves think of law and how do they use it? My mum's answer to this question was very simple. Not much is what terrorists think of law, and I can't believe the Australian government gave you money to write a book about this subject. But predictably, in such circumstances, rule from the barrel of a gun or the law of the jungle can, in some circumstances, come to dominate social life. But particularly in protracted conflicts, non-state armed groups often exercise authority in part by creating and enforcing their own laws and legal institutions. These can include what we'd conventionally describe as public law, that is, relations between a de facto public authority and the civilian population, including on matters of governance, regulation of resources and the environment, or taxation and revenue raising, criminal law, but also private law, including personal land, property and commercial disputes, family matters, inheritance, and so on. Now, despite the prevalence of this practice of non-state law and legal systems and its profound consequences for justice for ordinary people under their authority, international law and legal scholarship has largely neglected the existence of the law of non-state armed groups. We certainly talk about the application of international humanitarian law and compliance by armed groups with the law of war and the rules on fighting. There is a debate about whether and to what extent human rights obligations can or should apply to non-state armed groups. But there's really a complete lack in legal scholarship of grappling with the laws that non-state armed groups themselves create, apply and enforce, particularly those dealing with civilians, not those dealing with military rules governing fighters in combat. Now, in part, this neglect, I think, is because of, firstly, a jurisprudential refusal to recognise non-state rules as law. This is driven by a perception that insurgents, as I mentioned, are violent lawbreakers, destroyers of legal order, bringing chaos to failed states and ungoverned places. In my book, I challenge this commonly held perception that armed groups are lawless entities. Instead, I argue they're bursting with law and legal institutions in archetypally human ways. I show how our jurisprudential blindness to non-state law leads us to neglect how social life is often organised under conditions of conflict and discourages meaningful discussions about rights, fairness and justice in those contexts, as well as critically how the rest of us, foreign states and the international community and its institutions, should or should not engage with those law practices of non-state armed groups. Now, firstly, I just want to say a few things about why there is such a neglect of attention to these non-state laws. A couple of reasons. One is under international law, the state has the sovereign right to order its territory and people through the creation and enforcement of national law, including whether to recognise any non-state laws. In general, non-state actors don't get any legal personality or authority to make their own autonomous law. International law certainly contemplates the existence of non-state law, for instance, indigenous customary law or religious law, and even protects it under various bits of international law like freedom of religion, indigenous rights, minority rights, cultural rights, self-determination and so on. But those regimes do not normally authorise the wholesale displacement of state law, which remains the centre of legal authority. Under national law, secondly, armed groups are simply illegal. Any rules they purport to issue have no legal effect. Their edicts cannot be considered law, but are just unlawful challenges to the state's authority over people within their territory. Consequently, a rebel group which levies a tax, like Islamic State in Syria or Iraq, is just stealing or extorting, not administering a valid revenue law. In contrast to formally sanctioned forms of sub-state law, like indigenous or religious law in the private sphere and so on, the rules of armed terrorist groups are both outside and against the national legal system. There are also very practical factors why we haven't historically studied non-state law. When armed groups are underground, evidence of their law is just hard to find. Written records are often scarce. Armed groups don't write it down because if found, it's evidence that they're terrorists and they can be locked up for it. Norms often circulate verbally amongst members of armed groups, but it's difficult to interview active members of armed groups who aren't involved in peace settlements and wish to conceal themselves. So the second issue I want to then move on to is the issue of whether we should talk about these non-state rules and practices as law. And I think the starting point here is whether we call it law depends on what we're prepared to recognise and validate as law. If we step away from formal or positivist conceptions of law as that which is grounded in state authority or international law authority, it's easier to accept that armed groups have law. Of course, this isn't a radical suggestion in Western legal theory and international legal theory. Scholars have long critiqued simple views of Austinian conceptions of law as the rule-oriented command of an omnipotent sovereign to be obeyed and enforced by formal institutions following a separation of powers and so on. Domestic law is no longer the sole definition or archetype of what law is, and more attention in recent decades particularly has been given to pluralist, anthropological, sociological and private accounts of law as sub or supranational. Instead, if you see law as a normative system of principles, processes and institutions which seeks to influence social order and behaviour, sometimes but not always provide justice or settle disputes, then you get closer to recognising non-state law as law. Such an account of law suggests that it possesses a distinctive authority of its own, independent of raw power, arbitrary violence, rule from the barrel of a gun, or pure politics, morality, culture or religion, even if it's inevitably constituted by a combination of all of those things. Law may or may not have characteristics familiar to Western liberal legal systems like a constitution or primary and secondary rules, binding judicial settlement, a doctrine of precedent, a hierarchy of courts, or even a separation of powers. The essential criterion, I think, is that law has a capacity to meaningfully shape behaviour, whether by acculturation, persuasion, or coercion, and critically that it is recognised as law by the participants in the legal system. Of course, the substantive content of law can be good or bad. Law is not the same as justice. The existence of law is distinguishable from whether the rule of law exists or whether the law is legitimate. Just as we discuss law in many states that lack the rule of law, so too can we speak of law in the Islamic State, just as we speak of law in North Korea or Assad's Syria. Importantly, recognising non-state law norms doesn't render them lawful under either national or international law, but just identifies them as competing forms of authority and legitimacy and as opportunities to engage with non-state groups on how they treat civilians living under their control. Okay. Thirdly then, if we accept that this is a plausible account of law, then it's clear that many non-state armed groups, including terrorist groups, have established their own legal systems of various kinds, not only regulating how their fighters fight on the battlefield, but delving deep and wide into the regulation of civilians, civil justice and social life, as well as the creation of political systems under legal rules. The reasons why non-state armed groups resort to law as a technique of governance or control are many. I'll just list a few of them now, and we can deal with them more in questions if that's something you're interested in. But they, of course, include using law instrumentally to maintain social control. It includes using law to generate and regulate economic activity. Think of the Islamic State's oil ministry and oil licenses or cultural heritage licenses issued by the Islamic State in Syria and Iraq. Sometimes law is used to express a group's moral, religious or identity choices. Sometimes it's to win civilian hearts and minds by establishing public order and security in otherwise lawless places, including to fill vacuums of state authority or bad, corrupt, inaccessible state authority in the justice field. Sometimes it's to create legitimacy for external audiences, to get funding from diaspora communities, donors, and so on. And sometimes it's to show that the armed group is qualified to be a state. The FLN, the National Liberation Movement in French Algeria, developed a really elaborate discourse on law and legal institutions precisely so as to situate itself as a state in waiting, entitled to be treated with the respect due to a state upon independence. Okay. What then are some of the critical features of the legal systems that I've come across? And this is what I want to focus on. What are the sources of law commonly used by non-state armed groups, and what are the institutions? And then finally, I'll say something about what all of this means for the rest of us. Firstly, as you might expect, armed groups that have stable or effective control over territory are best situated to create the most elaborate and institutionalised and lasting legal systems, including, for example, the LTTE, the Tamil Tigers in northern Sri Lanka for many years. More recently, Islamic State managed to do it over a number of years before they were pushed out by the coalition in Iraq and Syria. That's pretty obvious. And in terms of the way that the international community approaches de facto state authorities controlling territory, in the Palestinian Authority in the West Bank, Hamas in Gaza, for all intents and purposes, the UN deals with them just as if they were states in terms of how they engage on health, education, justice reform, etc. So there's a lot of experience on that front, even if the UN has obvious diplomatic limits on how it can characterise what it's doing in those contexts. And of course, counterterrorism norms have made it difficult in some places, like dealing with Hamas in Gaza. I think more interestingly, though, there are also examples where armed groups which lack territorial control are still capable of exercising legal control over populations. whether coercively, because people fear if they don't obey, then there'll be consequences, or because people positively choose, so they forum shop, to pick the non-state armed groups' law and legal institutions over those of the state. One example is Aceh, which was a predominantly nationalist movement against Indonesian perceived colonial control, where Indonesia largely controlled the territory, but for some jungle areas. But many Achenese preferred to choose to use the parallel justice system established by the Free Aceh movement, because they were seen as more trustworthy, closer to the ideals of the people, and less like a foreign occupier as Indonesia was seen. Another example from the Tamil Tigers in Sri Lanka, where people, even in government areas, sometimes crossed into LTTE controlled areas to file complaints in Tamil Tiger courts, which could then summons people from government-held areas to appear in the Tamil Tiger courts. Now, obviously, this creates a forum shopping problem, but it does lead to a great deal of pluralism in these areas. FARC did the same, where it would compel people living in cities to appear before their justice mechanisms in rural areas. Okay, second feature I'd like to mention is that given that armed groups generally oppose the state, it might be supposed that the civilian or civil law that they create would be defined in opposition to state law. In other words, they want to overturn it, they want to replace it, and bring in whatever law suits their own political, religious agenda. In practice, however, the picture is much more complex, and there's often more legal continuity than there is transformative change in terms of the content and sources of law in areas controlled by armed groups. Now, sometimes, as in Afghanistan, this is because the armed group was itself once the state and has carried its law back underground, like after the fall of the Taliban government in 2001. So there was a continuity of prior Taliban state law by the now non-state group, the Taliban. In another example, the Tamil Tigers for a long time continued to use the Sri Lankan government's own legal codes and supplemented it with its own penal aspects of its own penal code. The Sri Lankan penal code itself derived from some Tamil customary cultural norms, as well as some prior Dutch law, and then there was a modernisation using human rights law. So you had this incredibly plural legal system. When Hamas took control of Gaza in 2006, it still maintained the Palestinian Basic Law, which was a law drafted by the Palestinian Authority, the Fatah-dominated faction. But it also fell back on increasing reliance on Sharia law, so religious law, which was culturally familiar to Gazans, as well as customary law itself derived from Bedouin practices of long ago. In terms of institutions, although they replaced the Fatah judges with Hamas judges, mainly because the Fatah judges refused to continue to serve under Hamas for the most part, they really encouraged the development of informal justice mechanisms, really in preference to using the formal institutions, even though they controlled them. So there was an increase in the use of reconciliation committees, mediation, arbitration, family power structures, the security service to deal with disputes informally, and many of these were increasingly infused and permeated with Sharia law as well. What I think this suggests is that pre-existing laws are familiar to populations under armed group control, and there are therefore significant costs in attempting to break from them, even when the agenda of the group is revolutionary. The Maoists in Nepal, for example, which were rebelling, in part against the feudal land and property structures in Nepal, nonetheless largely maintained in force Nepalese state law and only changed aspects of it which were unfavourable on land and property rights and also in terms of their own security, so dealing with informants rather nastily and so on. A group as seemingly religiously dedicated and inspired as the Taliban, yes, applied and enforced Sharia in Afghanistan, but also in practice largely relied also on cultural norms, common sense, political considerations, Pashtun customary law, and rules they created themselves, which they would just post on letters or posters at mosques or announce at prayers. As a fallback, often when there were gaps in these incredibly plural hybrid legal systems created by different groups, there was a fallback on a basic principle. So I remember talking to a Maoist judge in Nepal who said, look, if there was a gap, we'd just apply natural law. Likewise, a Free Syrian Army commander said the same thing when there was a gap in French or Syrian civil law. They'd just use common sense to fill in the blanks. But it was still an expression of a legal concept, as vague and arbitrary as that may seem. A lot of the judges and lawyers in these non-state groups are also themselves have legal training from various places. So they're not people living in the jungle or in a desert in a bubble. They come to these legal systems with prior training, with preconceived ideas about what law is and where it comes from. One great story I came across in Aceh was that many of the fighters of the Free Aceh movement had heard of the Geneva Conventions, and this is pretty on armed conflict, and this is pretty rare because mostly fighters know, don't kill civilians, don't steal civilian property, but very few can name, an international treaty. And eventually I discovered that their founding leader, a guy called Hassan de Tiro, had done an LLM with a famous international lawyer, Louis Henkin, at Columbia Law School in New York in the 1960s. And when he and his 1,000 fighters were flown to the Libyan desert by Gaddafi, Colonel Gaddafi in the 1980s to fly MiG fighter jets and so on, Hassan de Tiro drummed it into his men, good people respect human rights, they respect the Geneva Conventions and international treaties. So you get these examples where international law and the training given to leaders and lawyers in the movement can bring ideas about law into the movement. There are other examples where, for instance, armed groups have influenced the legal practices of other armed groups. So one of the most widely cited examples is when the rules adopted by the Chinese People's Liberation Army in 1947 were adopted by groups in Sierra Leone and Uganda in the 1990s. So you get this kind of peer-to-peer dissemination of legal ideas as well. Okay, the next, part of this story, of course, is reliance on customary law, and a big part of the book does deal with the many ways that customary law comes to assume a relatively greater importance in armed conflict than state law because of the breakdown of state authority and the usually fairly rudimentary institutions which armed groups, initially at least, are capable of establishing. One example is in Colombia, so FARC still continued to apply bits of the Colombian criminal code, but it also fell back on rural customary justice traditions. Sometimes it was called the law of the mountain or the court of the river, which was just a functional way of bringing order to places under FARC control. There are, of course, rarely, but there are examples of where armed groups do seek to wholly overturn and replace state law. And I think the closest example I've come across is Islamic State in Iraq and Syria. It has sought to make a pretty severe form of Sharia law the only source of authority in its caliphate. and in areas firmly under its control, like Raqqa and Mosul until recent times, it created a fairly elaborate structure of police and courts, vice squads and so on, to uphold and enforce its version of law, including intruding into dress, appearance, gender relations, smoking, playing cards, all of these activities of daily life which were highly regulated under ISIS control. Its courts were also pretty elaborate and well-resourced, with different types of courts for different types of disputes, with dedicated staff and so on. Even then, though, I would still point out that ISIS, many forms of ISIS's exercise of public authority and its regulation through its ministries and so on, really mimicked state forms of regulation, issuing permits, licenses, taking revenue through a fairly elaborate structure of public law. Now, one question which this leads us to is, well, if you accept that this is a kind of law, how do you then start talking about the legitimacy or otherwise of this law? If you accept that law doesn't imply justice or rule of law necessarily, how do you tell, or what kind of criteria do you use to evaluate this kind of law? Obviously, you could start from the international level, and you could see how this stacks up against putative human rights law standards or rule of law principles adopted by the UN and so on. In the political science literature, one of the ways this has been approached is by looking at what civilian populations think of this kind of law. And certainly there are quite a few cases where civilians living under this control have been, at least in part, supportive of the justice systems established by armed groups. This is most prevalent in cases where a national, let's say a national liberation movement aligns with the wishes of its people, and so there's a significant correlation between the fighters and those they control. But even when the armed group are not autochthonous, not indigenous, then they can still, sometimes attract support. Often this is not because non-state legal systems are paragons of justice, but usually because state justice in those places is so bad, inaccessible, costly, corrupt, protracted, unfair, and so on. By comparison, justice dispensed by armed groups can be accessible, speedy, not corrupt, relatively fair, and provide security, public order in places where the state was unable to do that. Some of the Maoist judges in Nepal would tell me, if you took a dispute to the Nepalese state courts, it would take years to progress through the courts. You'd have to pay bribes to officials all along the way, and then even if you got a judgment, it probably wouldn't be enforced. In contrast, you get stories from the Taliban where someone makes a complaint. A few hours later, a Taliban judge appears on the back of a motorbike, deals with the case. Everyone's afraid of the Taliban, so its judgment generally sticks. And you've got justice in a matter of hours, even in remote parts of the country where state justice never really ran historically. Hamas in Gaza, after 2006, largely cleared a huge backlog of cases in the judicial system under Fatah, which was also notorious for corruption in the judicial sector. Although Hamas politicised the justice system, although it introduced a greater degree of Sharia law into the legal system, it was known to be, on ordinary run-of-the-mill matters, fast and effective. Even ISIS was well received in some communities for providing security, so it would disarm communities of weapons. It stopped looting, unlike under areas controlled, for example, by the Free Syrian Army, where the FSA was less strict and organised on justice matters. It resorted to more commonly to mediation or families or clans dealing with disputes rather than dealing with it directly themselves. ISIS swiftly settled most minor matters, generally at the police station. It took action against complaints against its own fighters. It dealt out pretty harsh punishments, which served to deter. And it even, used the Taliban's trick of having a complaints box where you could file complaints against ISIS's own justice systems. The Taliban, like a similar story in parts of Colombia controlled by FARC, parts of Sri Lanka governed by the LTTE. In northern Sri Lanka, the Tamil Tigers provided court-appointed lawyers, gave free legal advice to the poor, didn't charge or charged only very low fees, and processed thousands and thousands of cases, had 3,000 police, and so on. A final point I want to make about the features of these legal systems is that obviously and this flows from the previous point I made, obviously the level of institutionalisation, that is the formal structures and mechanisms which apply the law, varies enormously from group to group. As you might expect, again, with stable territorial control, you can set up police stations and jails and so on. If you're being bombed every other hour by the US Air Force in Syria and Iraq, it's pretty hard to maintain working jails and police stations because those are targets for your enemy. But as I mentioned, the LTTE even had a law school training 300 lawyers a year. The Maoists in Nepal, in between, had mobile courtrooms where judges would travel from place to place and sit in the village and dispense justice. In Western Sahara, the Polisario, so the Sahrawi Arab Democratic Republic, had a parliament which Algeria allowed it to operate inside the refugee camps in southern Algeria near Tindouf. The parliament made laws which then applied across the border into the 1/3 of Western Sahara not controlled by Morocco and which is still patrolled by Polisario fighters and state officials. So a whole range of institutional structures. The Taliban, again, had a transnational structure like Polisario. 3 levels of courts, primary, provincial, but also a Supreme Court operating in Pakistan. So the highest tier of judicial authority is across the border in another country. Now, obviously, that's not the end of the story of legitimacy. What do people think of it, and how good is the institutional structure? Obviously, there are deeper questions of fairness, justice, rule of law, human rights, and so on, which I go to in the rest of the book. It's obviously an area which is also quite hard to judge. So a Maoist judge in Nepal, told me, we'd sit a defendant in a circle, the village would have their say about the case, and then we'd get a fair result at the end. I put that story to a member of a Nepalese NGO, and they said, look, this was summary justice, and the guy would have been denounced in a circle in the village and taken out the back and shot. So it's like a kangaroo court. Al-Shabaab trials in Somalia have been known to last a couple of minutes with the person shot immediately after. But the point of where this leads us all is that legal scholars, but more practically the international community and foreign states, have tended not to engage with these legal systems, in part because they haven't recognised them as law at all. And so that leads us to what that means for the rest of us. And I think we can say a few things about that in conclusion. One is, for foreign states, so all of our governments, there's a question of what does the law of non-state groups mean in our own domestic legal systems. If someone is born under Islamic State, or gets married under Islamic State, or gets a divorce or inherits property under Islamic State's law, should the Australian or Singaporean courts give effect to those legal judgments, decisions of a foreign public power, which we call terrorist, and which, by the way, is listed by the UN Security Council as a terrorist organisation? Or does recognising those private rights under a terrorist authority, does that somehow validate or give legitimacy, which we don't want to give to a movement like that? Likewise, if Polisario, as it is doing, gives resource exploration licences or rights to British companies to go into Western Sahara or to access fisheries off Western Sahara, should those contracts be recognised in foreign legal systems? So that's one set of questions. The second set is, what does it mean in terms of engagement by the United Nations and all the bits of the international system which deal with armed conflict? So humanitarian, post-conflict state building, and so on. Now here, the starting point is that we already engage with all kinds of armed groups in a number of ways. The ICRC, the International Committee of the Red Cross, and various other humanitarian actors already cooperate on the delivery of food aid, medical care, and medicine, for example, to even the most notorious, areas involving even the most notorious terrorist groups. Now, there are laws about terrorist financing and so on, which hinder or structure how that is done, but generally we have no problem with giving food or medicine through structures like Al-Shabaab in Somalia. I mean, we do it every day, even at present. The question is, how far can that kind of assistance and cooperation go? If we know, for example, so under human rights law, there's a right of a child to be registered at birth. That registration is generally done by a public authority. If you don't register a child at birth, it can, over the long run, lead to all kinds of really serious human rights abuses, like child soldiering, child marriage, child labour, child sex exploitation, statelessness, and so on. So it's a critical procedural step to prevent a whole bunch of really serious human rights violations developing. Does that mean, for example, that Australia or Singapore or the United Nations should give foreign aid or technical assistance to assist Islamic State to establish a birth registry, a registration of births, deaths and marriages like we have under the traditional British systems? Or would that be seen by too many states as somehow legitimating the public authority of that non-state group, making them more like a state actor by giving them the tools or things which make them look like another state? Birth registration is hardly going to give them more legitimacy than giving food to Al-Shabaab, which can then say that it's feeding its people and it's providing medicine and hospitals, even if that's all money and resources coming from the UN or MSF and so on. But these political forms of cooperation and assistance are generally seen as a step too far beyond the traditional humanitarian provision of food and healthcare and so on. Likewise, if we know that non-state armed groups have courts and are dispensing justice, should we be engaging with those courts to make them fairer? We all care about fair trial and rights of a defendant and so on. Does that mean we should provide, technical assistance to train non-state armed groups to dispense better justice? At the moment, we don't do that pretty much at all because we say they don't. We dislike them doing that. We say they have no legal authority to do it, and we say it makes them more like states and legitimates them if we do that. So that traditional response means we accept that non-state armed group courts are not going to be fair, and we're not going to try and improve the situation because we don't want to, at the political level, legitimise these groups. The final point is just to say, I'm not suggesting that we should engage on all of these matters with all groups, although even some of the worst groups in history we precisely have engaged with. I mean, even the Khmer Rouge, which was a genocidal regime of the worst kind in this neighbourhood, was, negotiating and engaging with various external actors at various points. So nobody, I think, should be beyond dialogue and beyond the pale. But obviously some forms of cooperation, some forms of assistance may give too much legitimacy which aren't worth the benefits. The costs outweigh the benefits. And so we need to think about where we draw those lines. Some groups, of course, the best thing we can do is kill them. That's obviously a judgment call in certain circumstances as well. So that's essentially what the book's about. It's just a plea really to map what's going on in all these non-state areas, work out what kinds of sources and content is in those legal systems, what kinds of institutions and mechanisms are being used, how do we gauge their legitimacy, and how do we engage to improve some practices where the benefits of doing so outweigh the costs. Thanks very much.